Welcome to my channel GSP Studies. Get ready for the dictation. 5 seconds. Start. Udoy Umesh Lolit, J hyphen leave granted stop. These appeals by special leave arise out of judgments and orders passed by the High Court of Kerala in criminal petition numbers Roman 1 808 of 2015 on 16/9/2015, Roman 2 859 of 2015 on 16/9/2015, Roman 3 858 of 2015 and Roman 4 670 of 2015 on 17/9/2015. Stop. Para. On the allegation that the appellant was involved in committing thefts, he was charged of having committed offences on different occasions and was separately tried in Roman 1 CC number 158 of 2004 before Judicial Magistrate First Class, Chavakad for offence punishable under Section 379, 414 read with 34 IPC, Roman 2 CC number 1039 of 2003 by Judicial Magistrate First Class, Chavakad for offence punishable under Section 379, 414 read with 34 IPC, Roman 3 CC number 390 of 2004 by Judicial Magistrate First Class, Chavakad for offence punishable under Section 379, 414 read with 34 IPC and Roman 4 CC number 1168 of 2006 by Judicial Magistrate First Class, Kunamkulam. Stop. By separate judgments, the appellant was convicted and sentenced in each of the aforesaid crimes. Stop. The respective appeals preferred by the appellant were dismissed by the Sessions Judge, Thrissur. Stop. The appellant filed criminal revision petitions in the High Court, which were also dismissed. Stop. The following chart would disclose the relevant details, para. These matters came up on 22/4/2016 when this court noted the submissions of the learned counsel for the appellant regarding concurrent running of sentences and issued notice to the state. Stop. The learned counsel appearing for the state has produced before us communication dated 27/5/2016 from the Director General of Prisons and Correctional Services, which is as under prisons headquarters. Stop. Para. According to the aforesaid communication, the appellant stands convicted and sentenced in 12 different matters, including the present matters, which appears at serial numbers 9, 10, 11 and 12 in the chart. Stop. Going by the sentence calculation, the sentence in the 9th case would begin on 30/8/2017 and finally, the sentence in the 12th case after getting all benefits of set off, would be over on 2/9/2022. Stop. Para. Section 427 of the Code of Criminal Procedure, 1973 is as under, para. 427 sentence of offender already sentenced for another offence, within bracket 10, when a person already undergoing a sentence of imprisonment is sentenced on a subsequent conviction to imprisonment or imprisonment for life, such imprisonment or imprisonment for life shall commence at the expiration of the imprisonment to which he has been previously sentenced, unless the court directs that the subsequent sentence shall run concurrently with such previous sentence. Stop. Para. provided that where a person who has been sentenced to imprisonment by an order under section 122 in default of furnishing security is, whilst undergoing such sentence, sentenced to imprisonment for an offence committed prior to the making of such order, the latter sentence shall commence immediately. Stop. Within bracket 2, when a person already undergoing a sentence of imprisonment for life is sentenced on a subsequent conviction to imprisonment for a term or imprisonment for life, the subsequent sentence shall run concurrently with such previous sentence. Stop para. In terms of subsection within bracket 1 of section 427, if a person already undergoing a sentence of imprisonment is sentenced on a subsequent conviction to imprisonment, such subsequent term of imprisonment would normally commence at the expiration of the imprisonment to which he was previously sentenced. Stop. Going by this normal principle, the sentence chart indicated in the communication dated 27/5/2016 is quite correct. Stop. However, this normal rule is subject to a qualification, and it is within the powers of the court to direct that the subsequent sentence shall run concurrently with the previous sentence. Stop para. In V.K. Vansal versus State of Haryana and another, within bracket 201307 SCC 211, it was stated by this court, bracket close, semicolon, para. It is manifest from section 427 within bracket 1 that the court has the power and the discretion to issue a direction, but in the very nature of the power so conferred upon the court, the discretionary power shall have to be exercised along the judicial lines and not in a mechanical, wooden or pedantic manner. Stop. It is difficult to lay down any straitjacket approach in the matter exercise of such discretion by the courts. Stop. There is no cut and dried formula for the court to follow in the matter of issue or refusal of a direction within the contemplation of section 427 within bracket 1. Stop. Whether or not a direction ought to be issued in a given case would depend upon the nature of the offence committed and the fact situation in which the question of concurrent running of the sentence arises. Stop para. This court then went on to club various crimes in respect of which sentences were imposed upon the appellant therein in 3 groups. Roman 1, the first having 12 cases, Roman 2, the second having 2 cases, and Roman 3, the third having a single case. Stop. This court directed that substantive sentences within first 2 groups would run inter se concurrently, and the substantive sentences in first 2 groups and that in respect of the case in the third group would run consecutively. Stop. The benefit was confined only in respect of substantive sentences and no কোয়া সেন্টেন্সেস ইন ডিফল্ট স্টপ। এই প্যাসেজের পিডিএফ পেতে টেলিগ্রাম গ্রুপে জয়েন করুন এবং ভিডিওটি ভালো লেগে থাকলে লাইক শেয়ার সাবস্ক্রাইব করে বেল আইকনটি প্রেস করে রাখুন সবার আগে নোটিফিকেশন পেতে। থ্যাঙ্কস ফর ওয়াচিং।